But first, we've got personal injury attorney Kirby Ferris. He's with us tonight to take a look at one of your email questions that one of our viewers has sent to us. The question tonight, Kirby, it comes from Christine, and Christine writes into us saying that my ex-husband bought our son a four-wheeler for Christmas. I'm very concerned about what will happen if he or one of his friends gets hurt while riding it. Who will be responsible for the medical bills? And I'm sure she's probably not alone with that type of question.
That's a great question. And you know, there's a common misconception here in Alabama that parents are responsible for the negligent acts of their children. And that's just not true. You're not responsible for the negligent acts of your children. Believe it or not, your children are responsible for their own negligent acts. But something to be aware of, this is also the law in Alabama. You can be guilty of negligent entrustment in Alabama. And what that means is that if, by way of example, if you have a child, family member, or just friend who you know to be a dangerous driver, maybe they've lost their license, had multiple DUIs, and you allow them to use your automobile and they hurt somebody, you are not responsible for their negligence, but it's your negligence in entrusting them with that vehicle that you can be responsible for. So, Christine, you're not responsible if your child injures somebody negligently, but if they prove to not be a safe rider of that vehicle and you still allow them to ride, then you could be responsible for that.